is Jamie Odell.
Mark Murray today. Hi, my name is Jamie Odell. I'm a civil rights advocate from Rochester, New York. I need to provide public notice to the Commission. This is in accordance with the U.S. CS Rule of Civil Procedures, as well as Rule 17, Rule 20 of the United States Supreme Court. The Constitution for the United States of America is the overarching requirements that every state must follow. I don't think anyone will deny that. States cannot enact their own alternative legislation and substitute and for guarantees of the Constitution of the United States. That would mean the state laws are more powerful than the Constitution. Clause 1 of Amendment 5 of the United States Constitution says, no person shall be held to answer for a capital or otherwise infamous crime unless a presentment or indictment by a grand jury. However, the state of Iowa has enacted in its own alternative legislation that permits the prosecuting attorney, police officer, or sheriff to charge by way of information, not by indictment as required by law. That is unconstitutional. Now, a emolument violation is when you pay a public official to break the law. The Constitution has two areas that enforce this. The article is Article 1, Section 10, where it says, no state shall create any law that shall impair the obligation of contracts. Officers, prosecutors, judges are all under a contract. A contract to perform that is based upon the oath or information that they took. The contract parameters are defined within the Constitution of the United States. So when the state enacts a law that directs their agents to disobey the law of the Constitution of the United States, that would be a violation of Article 1, Section 10. The 14th Amendment is the other place that you will find a reinforcement of this issue, and this is where it says that no state shall create or enforce any law that shall abridge by the privileges or immunities of the United States citizens. The privileges and immunities of the United States citizens are at a minimum. Those enumerated within the Bill of Rights, the first 10 amendments, they cannot be impaired. And thus the state of Iowa has enacted a law in its inferior constitution that is permitting public officials and law enforcement whom be paid to violate the Constitution of the United States. As a result, there is no inordinate amount of people currently in prison in the state of Iowa legally and unconstitutionally. Tanala Downing is preparing and litigating this issue, and that the United States Supreme Court, on behalf of more than 700,000 people currently in prison here in America unconstitutionally, I'm here today to notify you that if you continue to pay public officials to break the law, there could be criminal sanctions that could come from that. We don't want to go down that path because we believe it will be very messy, but you officials must be made aware that paying people to disobey the law is an emolument violation, it is illegal, it is unconstitutional, and it is a crime. I'm asking you, honorable individuals, to please look at Clause 1, Amendment 5, confirm what I'm saying to be true, and then direct your public officials to act in a lawful constitutional manner consistent with the obligations that are codified in the Constitution of the United States of America. I have noticed that I would like to put on the record.
You're over your 3 minutes.
Excuse me?
You're over your 3 minutes.
Okay.
I'm sorry, the last bell was your 3 minutes.
I'm sorry. I'm working. Who can I get this to?
You can leave it up here. Thank you.
Thank you.
Okay, thank you, sir. Our next speaker is Tawana Downing. Morning, sir.
Yeah.
So my name is Tanner Downing. I'm a civil rights advocate litigator out of Washington, D.C. that just talked about. I want to provide clarification. The state of New York has enacted its own alternative legislation that permits prosecuting attorneys to charge by information as opposed to indictment. I know that the statement said Iowa. We're actually talking about the state of New York here. So I want to provide a little bit of clarification so we understand what was just said and what we're actually asking from all of you as a legislative body here, because I think that's really, really important. I have approximately 52,000 criminal affidavits on behalf of victims that have been charged by way of information as opposed to indictment from right here within the state of New York. Many are from within Erie County. These affidavits say identify two crimes in particular. The first crime is Title 18 U.S.C. subsection 242, which is deprivation of rights under color of law. What that statute says is that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution commits that crime. Now, the second crime is Title 18 U.S.C. subsection 241, which is conspiracy to deprive rights. What that states is that when two or more persons conspire with the purpose of depriving any person of any right secured by the Constitution commits that crime. Now, the law is a criminal conspiracy with regard to public officials. That's all of you. What that states is that any person who, having knowledge of any of the wrongs conspired to be done and who have the power to prevent or aid in the prevention of the commission of same, neglects or refuses to do so, may be joined to dispense the action. So upon having been provided this notice, letting you know that you guys are paying public officials, the Sheriff's Department, to go out and execute unconstitutional warrants that are based upon the incorrect charge and instrument, I'd ask you guys, please, let's work together to fix this problem. I'm not here to get anybody into trouble. That's not what this is about. I'm here to raise awareness on an issue that we're going to get addressed because I'm preparing to argue this in front of the United States Supreme Court on behalf of these hundreds of thousands of people that have been unconstitutionally charged in violation of the Constitution of the United States. And so, I think that it's important that we raise awareness on this issue so that all of you can understand that when you pay people to violate the Constitution, even under an inferior state statute, that is a crime. And I don't want anybody to get into trouble. I don't want you guys to get into trouble. I really don't. So I know that you're going to go to your attorney and you're going to ask the attorney as soon as we're done whether or not what I'm saying is true. And that attorney's going to point you to a case from 1884 called Hurtado v. California. And before you choose to rely upon that as the foundation, I must remind you that the Constitution of the United States of America is the foundation, not a judge-made ruling. The Supreme Court of the United States has no constitutional authority to be able to alter, amend, and destroy any provisions that guarantees the Constitution, because that must be done by an authentic and explicit act of people in accordance with the special amendment procedure of Article 5. Furthermore, judges cannot legislate. We know that. It's Clause 1, Article 1 says all legislative power is vested in the Constitution of the United States. So I pray that you guys will make the right decision here, right? I know it's a very difficult decision because as soon as we're done, you're going to have to decide whether you're going to follow a judge-made ruling, the lowest form of the law, or the Constitution of the United States of America, the object of which your fidelity is bound. And I'm going to pray that you guys make the right decision. So I know my time is up. Thank you guys so much. God bless and have a great rest of your day, okay?
Thank you, sir. Our next speaker is Jessica Saxton. Barney?
Good morning. Thank you so much. My name is Jessica Saxton. I'm also a civil rights advocate and litigator from Washington, D.C. As Mr. Downey was just saying, the Supreme Court is, the Constitution is the supreme law of the land. There's no state, no county that is able to enforce or enact a law that is outside of the jurisdiction of the Constitution. Across this nation, children are being removed from fit, loving, healthy parents, not because of abuse, not for danger, but strictly for profit. Under Title 4D, Title 4B, and Title 4E funding, we know that the state and thus the county receives federal funding for any child that is removed, regardless of if that is an unlawful removal. This means that the system is literally profiting while families are being destroyed. It is true that a portion of this county's budget contributes to the operation of the very courts that are participating in the unlawful removal of children. When the government officials, including judges, attorneys, clerk of court, your law enforcement, and other county-funded agencies knowingly or negligently deprive citizens of their rights that are secured and protected by the Constitution, that unfortunately is a federal crime. It's a federal crime under 18 U.S.C. subsection 242. That becomes a criminal conspiracy under 18 U.S.C. subsection 241, when two or more actors conspire against the rights and deprive your citizens of this county of rights that are secured and protected by the Constitution. Under Title 18, subsection 4, you are required to report when you've been made aware of crimes that have been committed in your county. In the very near future, I will be serving affidavits of criminal conspiracy against judges in this county who are unlawfully removing children from families, from mothers, from fathers that are fit to raise their children. They're putting these children into foster care. They're putting these children into the system for nothing more than the profit for this county. As elected officials, you all here swore an oath to support and defend the Constitution. Because this commission allows and allocates funding that enables these courts and state actors to operate, they continue to fund these courts to operate unconstitutional practices. After receiving all these notices, you are now placed at risk in being implicated in the ongoing violations So we are calling on all of you to immediately withhold any funding at the county level that supports or enables these actions until compliance within the Constitution is restored and that every child that has been removed unlawfully and put into state custody is returned. There's no court that can operate morally when they're in violation of the Constitution. And definitely not lawfully. Thank you.
Thank you. Next.
The truth